Friends, hello and welcome to another episode of The Legal Breakdown, hosted by Sansone Howell, Attorneys at Law, and KTLV 1220 AM. I'm your host, Jason Sansone, and we're glad you join us on this April 10th day. As always, The Legal Breakdown airs from 5 to 5:30 p.m. every Wednesday. You can listen to the show on KTLV 1220 AM terrestrial radio or through the TuneIn radio app. In addition, we stream live through Facebook Live. You can find the link to that through the Sansone Howell Facebook page, or all former episodes are available on youtube.com and in audio content as a podcast on the Spotify directory, through Apple iTunes, and through the Google Play directory. In addition, we are always happy to take your calls. You can call us live at 405-347-7238. Once again, that's 347-7238. Or if you are on social media watching this on Facebook Live, you can ask your questions through the social media app. Friends, today we're going to talk about a very interesting topic with a little bit of history and then dig into where we stand now at present, and that is the idea of fee shifting or attorney's fees. That the American rule in the United States is that the prevailing party, the person that wins in any type of court case, doesn't get to recover their attorney's fees. You pay your own way. So let's back up. Let's talk about the history of our country, how we got there, what that means now, and then under what circumstances you can get attorney's fees. So the United States, as we all know, started originally as colonies from the United Kingdom. Under the British system in the United Kingdom, you are almost always going to recover attorney's fees, that the losing party has to pay for the winning party. However, that has some negative consequences, one of which is that they cap how much the fees can be, or at least historically they did at the times we're talking about before, for example, 1776. And so one of the concerns with that, in capping the amount of compensation very low by certain standards that attorneys could receive, is we weren't necessarily entitling people to the very best possible attorneys, that your counsel could have been better in a more free market economy. And it also causes a barrier to the access to justice, that in the United States mentality, having people pay their own way doesn't have the chilling effect of every time you go into court, guaranteed the other side's going to have to pay for you, and that you're more likely to bring litigation, you're more likely to defend litigation if you're not automatically thinking you're going to be stuck with the bill for the other side. And so you're willing to possibly explore things like civil rights litigation, where you might lose, but you still did something that was valuable, that you still brought focus to a problem, you still litigated a very important issue of the time. And so that's one of the reasons we have the rule we have. But so going back, in the United Kingdom, first off, it's important to understand their system's very different than ours. They have two categories of lawyers, barristers and solicitors. Now, those are terms you've heard in the United States, but they have a different meaning. A barrister is someone who goes to court on your behalf. We think of them as someone who's a litigator. So I go to court. I was in court 3 times today. I also met with clients in my office. The difference there is that we do everything in the United States system. We are a licensed attorney. Over there, a solicitor is the person who's going to do all of the out-of-court work. They're going to meet with the client. They may draft the documents. They may do the transactional side. They prepare the briefs, the pleadings, but they don't argue it in court. They're not the litigators that we think of. The barrister is. So that's one of the reasons we see this distinction between what attorneys can charge and whether that's billed directly to the client or whether that's going to be pushed off to the losing party. But really, the big piece of history that matters to this idea of the American rule is that our country was founded on these principles of capitalism and business and free enterprise and wanting to enable people to be the best they could be and explore and grow. Well, we felt that that meant we needed to decrease some of the caps, some of the barriers for attorney compensation so that the best and the brightest might want to be attorneys to pursue that profession just like they could pursue business and make a living. But as a trade-off, that meant you didn't get to bill it to the other side. That if you want to have the very best lawyers, the very best law firm humanly possible, that's your choice. But you're going to pay for it, not necessarily the other guy paying it just because you wanted to have the best or most expensive attorneys possible. So that was a bit of a trade-off that occurred in the early formational years in the case law and the statutes that emerged from the United States. And so what we saw was this creation of the American rule. It was a deviation from the British common law system where the prevailing party could recover fees. And so now that we've talked a little bit about the history and we understand that the broad rule, the American rule, is if you go to court, you're going to pay for your attorney. That's an important basis, and it's also important to the scope of this show because we're discussing this in large part because it's important people understand that. There's a lot of misconceptions, and I find a lot of times people don't realize that is the baseline rule. And so even if there is a chance that you could recover attorney's fees, you need to remember that it's not a guarantee. It's never a surefire thing you're going to win, and you're going to be paying quite possibly your attorney all the way up until you might recover attorney's fees. And that is, in essence, no different than gambling. It's an educated guess at best. And so you need to be aware that you can't just think, well, I'm going to run up a huge tab because I'm going to make sure that's going to be paid for by the person I'm suing or by my spouse after this divorce. I'm going to grind the axe and have a $25,000 divorce attorney bill, but I'm not going to have to pay that. Careful, not so fast. So then what lets us deviate from the American rule? Well, in most states, and in the federal system and in Oklahoma, the only way you deviate from the American rule is by statute or by agreement. Well, what does that mean? It means that either by law has been made that says under certain circumstances you can recover attorney's fees, or the agreement between the parties, the contract says you could recover attorney's fees. And that's important because those are the only two ways. We agreed to it or the law says we can. Now, I'll admit, we've whittled away at the American rule quite a lot in this country, very considerably, even though we say that the rule is you don't get fees. Even in Oklahoma, I've got here a list I put together, and it is over 4 pages long, of examples of statutes in which you could recover attorney's fees, in which there are ways to do it. Just some examples of things that might allow you to recover attorney's fees: personal injury cases, cases where the state has sued you but it was frivolous or unreasonable, you might recover your attorney's fees against the state. Certain intellectual property type cases, circumstances involving child custody, involving divorce, actions to enforce a lien, actions to recover money judgments, actions under Natural Gas Market Sharing Act. And we could sit here and read all these off, but the point merely is an example that even though we say only in these circumstances, there's a lot of circumstances. A whole lot of circumstances. And, as we already touched on, agreement. So even if the law doesn't say so, if your contract that you're litigating on says so, one or the other party may be able to recover attorney's fees. Well, so that then brings us to the next point. And the point is, well, under what circumstances, even if they're allowed, do you get them? It's going to depend either on the language of that statute or the language of the contract clause. And the problem there is they're all over the map. In Oklahoma, there's at least 6 different statutory constructions, 6 different languages used that allow you to get attorney's fees to create what we call this fee shifting. And I don't think we've touched on it yet, but why do I call it fee shifting? What is fee shifting? Well, shifting meaning that the fee is now shifting from the client, the person that hired the lawyer, to the other side, to the losing litigant from the prevailing litigant. And so that's why we call it shifting, because it's no longer a first party fee agreement, but one that's being put on, the burden put on the loser. But to just go over some of these different languages, for example, sometimes the statutes read, the court may, in its discretion, award reasonable attorney's fees. Alternatively, it says, The prevailing party may be awarded attorney's fees. Attorney's fees shall be allowable to the prevailing party. The prevailing party shall be entitled to attorney's fees, or reasonable attorney's fees must be awarded to the prevailing party. Well, so why did I run through all that? What does all that mean? Well, number one, it doesn't always mean that just because you won, you'll get fees. Sometimes the fees are both for the winner and the person that brought the action, meaning the plaintiff or the petitioner. Under some of these, the defendant or the respondent can never be awarded attorney's fees, even if they were the one that won the case. Even if the defendant wins, they don't always get fees, but sometimes they're only limited to the respondent or the petitioner. Sometimes they must be awarded if you win, although they must be reasonable. Other times it's at the discretion of the court that they may be allowed. Equally important is because all these have different languages, it's going to depend on what type of claims, what type of lawsuit you have brought. So, for example, you file a big lawsuit, civil litigation. You've got what we call 5 causes of action, 5 different things in that case that you're listing of why you should win. Well, what if some of those allow fee shifting, allow the recovery of attorney's fees, and some don't? Well, that would mean that then the award at the end is going to have to be prorated. It's going to have to be apportioned into those different categories, or it'll spell out those different categories, and you're going to have, or your attorney's going to demonstrate how much of the work was for each of those different categories, because you can only recover fees where they're allowed, where they're authorized. So you wouldn't get them if you won on causes of action on areas that don't allow recovery of attorney's fees. So it gets even more complicated on that front. So we've identified that baseline starting point in the U.S., you don't get to recover your attorney's fees unless the agreement says it or the law says it. Okay? Well, if the law says it or the agreement says it, then you have to get into the nuance of what does the language say. Does it say you must receive them? Does it say you may receive them? Does it say that you have to be the petitioner or the respondent? Which party's allowed? And now we get to this point of reasonableness. That sounds straightforward, but believe me, it's not. And that's why we're going to spend a lot of the rest of the episode on this idea of reasonableness. I'll point out that we've used up about 15 minutes of our show. We're halfway through. It's a great point here. I want to reiterate to all of our listeners, if you have questions about this, or, even if you got questions about something else, feel free, interrupt me. Call in 405-347-7238. So now here we are, 15 minutes to go. We're talking about the reasonableness of attorney's fees. That is critical because, as I already mentioned earlier on, you cannot just run up the bill to whatever you want, or your attorneys run up the bill to whatever you want, and think that you're guaranteed to stick that on the other side. That I got into a dispute with my wife, we filed for divorce, I went out and I found the biggest law firm in my state, and I told them, you've got a blank check, put 10 lawyers on my case, bill it $1,000 an hour, spend as much time as you need, don't worry, we're going to get this from her. Well, again, not so fast. Reasonableness is going to dictate what the recovery can be. In the federal system, there's what's known as the lodestar test, and that comes from a United States Supreme Court case. In Oklahoma, the lodestar test has been adopted by the Oklahoma Supreme Court with certain deviations and modifications. And that particular case, very important in the state of Oklahoma, it's State Ex Rel Burke v. City of Oklahoma City. And that is a 1979 case. And so that goes into the factors that an attorney has to demonstrate to have reasonable attorney's fees. It's very long. It has over 12 points. We're not going to possibly go into all of those or discuss that on the radio. We're just going to start off with the big picture, which is first, determine the hourly compensation on an hourly rate basis, and then add additional amounts based on the following guidelines. And the guidelines are where I said there's 12 points. Those are known as incentive fee or bonuses. The first part is the time compensation factor. Well, it's honestly pretty straightforward. What's a reasonable amount of time times a reasonable hourly rate? So you should have spent 10 hours, and a fair rate was $200 an hour, so you would recover $2,000. So either of those categories have to be reasonable. You have to prove them up with experts. And it's all based on the prevailing standards of the community, what is appropriate at the time. Most likely, you're going to bring in expert witnesses, you're going to bring in other attorneys, you're going to demonstrate what is a reasonable fee times a reasonable time. So for example, we went back and I said, you walk in and you say, I want to pay this law firm $1,000 an hour for my divorce. Well, if $1,000 an hour is not the going rate, is not reasonable to be compensating where you live for that type of work, even though you may have paid for it, even though your attorneys may charged it, you may not be able to recover at that rate. It may be that 200 is reasonable or 250 is reasonable. Now, it's very, very regional and fact specific. In the state of Oklahoma, $1,000 for a divorce attorney would not be reasonable. That would be completely egregious. But you could probably get 300 or 350 if you have an experienced 20-plus year attorney that focuses in divorce law and you have a complex case. That might be reasonable. Then there's the issue of time. And time's even more complicated than the question of the hourly rate because you're going to have billing records. You're going to show all the time you spent. Some of the big no-nos that'll get time tossed out are, number one, billing for non-attorney activity, clerical duties. So you can't bill a paralegal at $200, $300 an hour for making copies, for running to the courthouse to file a document, those types of things. That would be something that if you were defending a fee application, you would push back on because it's not reasonable to be paying attorney's fees for non-attorney work. Another huge issue is what's known as block billing. And block billing is where you're not specific with individual activities with small increments of time. So if, let's say, I spent my whole afternoon working on one case for a client. I made multiple phone calls, I made multiple emails, I got and did some legal research online, I then printed that research, I began drafting a motion, I completed it, I reviewed it, I filed it electronically in a federal case. It would be inappropriate to lump all that into one statement and say 4 hours. That is a block bill. Saying 4 hours of time with a whole bunch of activities doesn't tell me what I spent on each of those activities. Did I spend an hour on a phone call? Did I spend 15 minutes on a phone call? Your attorney or yourself in these types of situations wants to make sure that you have specific details because that way the court can know how much time has been really invested into every activity. So block billing's a big no-no. Another issue is the increments of time that are used to do the billing. It's going to depend entirely on, again, the community standards. For example, most of the time using quarter-hour increments is unreasonable because if I make a 5-minute phone call, I should not round that up to 15 minutes and attempt to charge for that. The most commonly accepted standard is 1/10 of an hour increments because that's 6 minutes. It's a smaller piece of time. So you should bill time at 0.1, 0.2, 0.5, 0.7 increments of an hour, not quarter-hour chunks. That's another thing that would get you in trouble if you tried to file a fee application and try to be awarded attorney's fees before a court. So we're still talking about this idea of reasonable time. We touched on you shouldn't block bill, you shouldn't bill for in increments that are too large. You can't bill for activities that aren't really legal in nature. Another example of things that you can't bill for is research. Now, it's reasonable to spend an appropriate amount of time on a complex or nuanced issue. On the other hand, many courts have said you don't have to pay for someone's legal education, meaning, let's pick a topic that I personally don't know the first thing about. I don't know the first thing about immigration law. Don't come to me for immigration law. I fully admit to lacking competency on that topic. So if someone came to me and I took their case, and I then had to spend 20 hours familiarizing myself with U.S. immigration law, doing all the research, going to CLEs, I bill for all of that. We win, and somehow I have the ability to have a fee award against maybe the United States government. We're making a lot of this up, but I'm giving an example. And I ask for 20 hours time in doing research, well above and beyond the amount of time that would normally be necessary to research and familiarize myself with this particular case. That's non-compensable because it's not appropriate that someone should have to pay for your attorney to basically learn how to do their job. You learn how to do your job, but you don't get to bill that to somebody else or to your client when you weren't prepared or competent in the first place to take the case. So that's another example of the types of things that are going to get you sideways if you're trying to receive, or possibly you want to look at this if you're defending what are known as fee applications. So once again, summarizing some of the things we've talked today. You are a client or potential client of a law firm. You're thinking, I need to defend or prosecute an action. That one way or the other, I'm going to be involved in a case. Could be civil litigation, could be some type of domestic litigation, paternity, custody, divorce. Remember, we already discussed, the American rule is that you're going to pay your own way. You are not going to recover fees from the other side. But you might. And equally beware that if you lose and they have the right to recover, you may find yourself in a pickle if you unnecessarily ran up the litigation. So where there is fee shifting, one thing that's important to remember is neither side needs to be unnecessarily litigious, that taking action solely for the sake of dragging out the case, of delay, of driving up costs can most assuredly backfire either in a sanctions award under the federal system would be Rule 11, in bankruptcy 9011, or Oklahoma Federal Rules of Civil Procedure 2011. And any of those, basically the same idea. You could get sanctioned if you're inappropriate, or possibly still just recover attorney's fees. We then went into the issue that even where you can recover fees, there's all different language on how those are awarded, whether that be must, may, shall, which party can recover. It's going to dictate, including possibly if you're under contract, what the clause says, whether or not you're going to get fees. And then last week we got to the idea of reasonableness, that the fees must always be reasonable. And reasonable is not just a generic term. It's what we like to call a word of art. It has a very specific meaning, that reasonable has been defined by the courts with much, much case law history. In fact, you could easily go right now and you could probably find 40 cases from the Oklahoma Supreme Court dealing with this issue of reasonableness and fees. We went over the fact that with that reasonableness, you're going to have a starting point under any system, whether it's the state or the federal, whether it's what we call the Burke factor, whether it's a lodestar test. The starting point is going to be reasonable time times reasonable hourly rate. Those are all based on what the reasonableness is of that community. Doesn't mean that you can get away with where it's reasonable in New York City, in Oklahoma, or what might be the going rate in LA, in Tulsa. It's going to be based on the community standards, the type of case that's being either defended or possibly prosecuted. So you're going to have to demonstrate what that hourly rate should be, and then you have to demonstrate what the hours are that were reasonable to expend in the case. We touched on some of the things that are always going to be unreasonable. Unreasonable things are where you bill in too large of an increments, where you block bill and you stick everything together, where you may be trying to bill for research, or where you're billing for non-legal, ministerial, clerical type activities. those are going to be things that are unreasonable. Even though your attorney may have tried to charge you for that, you might have been agreeing to pay for that. The other guy isn't going to have to pay for that. So friends, we've discussed all these things. We've summed it up. The lesson here, overall, in addition to the history, is remember, law is not gambling. The idea that you should be acting on the principle of thing can be very dangerous. You need to make sound decisions based on the advice of counsel and your own wisdom. You should not pursue something under the idea that you guarantee yourself, as a fallacy, potential recovery, and realize that you can't just run up a bill and may not have to pay for that, or have to pay someone else's bill exorbitantly. Always conduct yourself appropriately, professionally, and reasonably. So friends, this has been another episode of The Legal Breakdown. I look forward to another opportunity to speak and talk with all of you next week, 5 to 5:30, Wednesday. We will see you then. Have a wonderful evening, friends.